What is the most important thing for taxpayers to know about the IRS appeals process? Well, I've said it before, I'll say it again. If you allow the 90-day period to lapse without filing a tax court petition, even if the IRS doesn't have the facts right, they don't have the law right, their assessment becomes legally collectible and they can go straight to collection action. Moreover, the only way to get them to take another look at the issue is through a process called audit reconsideration, and this is not mandatory. This is optional on the part of the IRS. A lot of times when you ask for it, you'll hear no. The most important thing I can tell you is if a 90-day letter is running on your issue, please contact me as early as possible in that process so I have sufficient time to weigh the facts and the law in your case and determine whether an appeal is a good option for you or not. Frankly, if my legal fees make your situation worse, if I can't better you by reducing the tax liability by more than it costs you to fight the appeal, then it doesn't make economic sense to fight the appeal, and I will not recommend you fight an appeal in that situation. But I will tell you this, that's a matter of judgment and no guarantees can ever be made. When is the filing of an appeal inappropriate? Well, if your only concern is that you can't afford to pay the taxes that are due, along with the penalties and interest, and your desire is to delay the collection action of the IRS, that could be considered a felony, tax evasion. That's inappropriate to bring litigation in that situation. It's also inappropriate if the only communication you got from the IRS was a bill that they're trying to collect on. An appeal is probably not proper in that situation unless it's a collection due process appeal.